don't commit crimes. Then you can take care of your job and your other responsibilities, but crimes kind of intervene on things, and they are become the most important thing if you care about your freedom.
Well, instead of 4 weeks, if you wanted to go with a 2 week or a 1 week.
Well, I want to see him tomorrow.
Well, actually, I'm not going to be here. I'm available tomorrow.
I want him to be here tomorrow.
Without me?
Yeah, I'm going to drug test him. Just
to test him.
I don't care, but they're not present.
Positive.
So
For THC, Vaughn
I can get him in later.
was
Yes.
raised and he was taken into custody back in.
I don't like that.
If you want me to bring him in later at orientation today, I'll be here. You'll be here. You can test him, but
Yeah, but it's on his terms now, not mine.
well, if he didn't go to his orientation, he'd lose all out of his new job he needed to get, and he's trying to better himself. And
Well, I know, but once again, it's hard to be here. We're in a
There's no
docket and
rescheduling.
we're still in the
I'll be
docket.
asking
Just
for
starts the
reset.
docket,
He has-
it takes off on his own. Somebody asks first, which now I'm not in
I was
control
trying
of
to
this.
ask before, but I could not.
I know, we're kind of busy,
I know we're busy. That's all. We've
but
been
that's
busy
what
the
happens.
last few days.
That's,
So
you know,
I will take the blame.
You know what I
I
say
didn't
is-
ask him. I didn't
you
ask
know what
him.
I tell people? Willard, you need to borrow a coat or anything? You got socks? Everything, he's okay? Is he dressed? He's working?
I love the book.
Your guy is, Mr. Bowden, Floyd Bowden.
I didn't get him to sign his tab.
Okay, let me know when you're ready. Lorenzo Walker. Where's Lorenzo Walker? Brittany Holmes is your attorney? There's Brittany right there. What are y'all doing on that?
I don't know.
You don't
Well,
know.
last time-
You want me to tell you?
It was reset,
It's kind
because
of,
these are family.
it's a
members.
year old.
But we were, if there's no resolution, we're going to just request it. But we hadn't received.
Oh, isn't that
We haven't-
always the case? If you don't get a resolution, you go to trial.
She just reminded me of a conversation, Judge. I mean, literally 2 seconds before you called us up. So if you give me a moment, I'll
What
see.
conversations?
From,
Oh, I wasn't involved in.
No, sir, it was an AB conversation.
Oh, okay, leave me out of it.
More likely it's a BC conversation because you're,
I'm not gonna get upset.
give me a moment to take a look at that.
Everybody
Judge.
else was invited to that meeting but me, but I'm not gonna be upset.
Thank you.
All right, on Derek Leger, that was reset, I guess, for how long?
Quick one.
Nathaniel Clark?
Yes. I was a court appointed attorney. I was just informed that he has retained counsel, so I'm going to
Okay.
step back and turn it over to.
And you, or Mr. Manning?
Yes, sure.
Okay. So let's see. You're charged with, you're Nathaniel Clark.
Yes, sir.
Do you understand you've been indicted, and this was 7 months ago, for the third degree felony of operating a motor vehicle in a public place while intoxicated? You have, though, that's not the worst part of it. You got prior convictions.
You got
Don't interrupt me. When I'm through, you have a fair opportunity, okay? There's, according to the grand jury, in 1997, you were convicted of illegal possession of marijuana out of Wichita Parish, Louisiana. My family's right. Then the third paragraph goes on to allege that after that felony of illegal possession of marijuana was finalized, you committed the offense of aggravated battery and were convicted in Wichita Parish, the same fourth judicial district court of that offense of aggravated battery in 99. So if you are convicted of this third degree felony of operating a motor vehicle in a public place, and if these two other priors are indeed valid, then you're looking at no less than 25 years imprisonment to life in prison. Do you understand what you're facing according to this indictment? Yes or no?
Yes.
Okay, as long as you know that. And also, you're not eligible for probation for this office. So what are we going to do? Excuse me.
I'm sorry, go ahead.
Oh, yeah.
I'm just aware of the situation.
Yeah, well, that's what happens when I was defense attorney a long time. So those things fall in your lap, but I don't, I don't wait around. I move forward,
Oh, yes,
especially when it was indicted last year.
right. So believe that we're working on the discovery.
What is that? Okay, it's 7 years. What happened to the guy before? He was representing him.
John West.
Well, John, you had him for 7 months. Did you pass all the information to Mr.?
No, I had him for 7 months. He's been following. I wasn't appointed that. Not sure when I got appointed. I was appointed recently. I've only had one court date here.
And at that court date, Mr. Clark did not appear. He had a failure to appear and you increased his bond to
You were the
$100,000.
attorney in January, as of January. And there was an initial docket. It was reset until February, and then that was reset until March.
Yeah.
Then that was reset until May, and then that was reset until later in May, and then that one was reset to, I think, today. Yeah. So what is that, 5 resettings? Bad gum, come on.
Yes.
All right,
I don't know if off the top of my head, Your Honor, I can't.
Have you related things to your prior counsel as far as the office?
Yeah.
Oh, often was.
Yeah, we did.
We didn't get a chance to get to that. That's it. So it's 4 versus 4.
what are y'all gonna do? What are you gonna do?
Well, I have concerns with Mr. Clark because he failed to appear. You increased his bond to 100,000. He posts the bond the next day. He gets out and he's alleged to have committed a new assault, family violence.
I'm not aware of that.
I filed a motion to increase his bond, and that is actually what this is set for this morning.
Okay, okay, I'm looking at it.
Yes, sir.
And what happens, you tip me off ahead of time.
I apologize.
That's okay. This was filed on the 9th, but when it goes into the file, I don't see it until I break open the file of the docket. This states he's accused of family, an injury to a family member in 26 CR 1567. Can you pull that for me?
Gotcha. 08766. Sorry, what did you need, sir?
So you tell me.
26 CR 1567.
If you're interested about the PC, Judge, I have that from
I just want to know, I want to look at when that got filed and
it was filed on June 5th. The offense occurred on June 3rd.
I can go.
why did we increase his bond?
We increased his bond because he didn't appear in court properly on May 27th.
Did you?
And the next day he goes down to the jail that day and posts the $100,000 bond. And then within 5 days, he's alleged to have committed a new offense.
Did you let me back to see it's not important?
Why would I know that, sir?
No, so they did our counsel like anybody had to you.
Again, why would I know that?
Right.
I thought you were clairvoyant.
I've been told a lot of things. That's not one of them. No, sir.
Your first name has not been known as Claire.
No, sir.
Well, that's what he just related to here. There's issues here. Moving with another court.
I don't care. What I care is that he was out on bond and commits a new offense.
Yeah. Well, no, I'm saying as far as it looked accessible, the failure to appear.
Sometimes it's
Sorry, Judge.
Sometimes it's amusing.
He
just
keeps
listening to you.
visiting with me instead of
He's
your honor.
lurking. He's trying
Yes,
to
sir.
figure it out.
Yes, sir.
I was defense attorney for a long time and things always surprised me I was the last to know a lot of information about my client.
Well, now, as far as that goes, Judge, he has taken the original step to go through the portal to get discovery. I've seen the initial email and the response from the district clerks, but that has not been cleared. He's going to have to get with the clerk's office because he's new to the system. And so he has not had access to the
Okay, so now,
Okay.
we don't have their files, nor can I have access to it like their stuff. If Mr. Ham has the PC, that might be the only way. we can get
You
it.
have the information.
At the PC here,
No,
I can
the
print,
information.
I can print you out that, Judge.
Thank you.
Yes, sir. Give me one moment, Judge.
Sean Villar's Hamilton. Like, my boss and your boss talking about this, and I go, but don't move, so I'm just gonna go do things and look down later. Yeah. Didn't trickle down last week. So, he said it all, but I don't know anything about his house. If I didn't, somebody was like,
We have a copy of this.
I hadn't seen it.
Okay, we'll make a copy.
It's gone. It's go to August. Okay, cool. Did you still know? Is the original, was the original for only 10? Yeah, it's not that good.
Yes.
Curious, was it any analysis suggest why they go from 10 to 1?
Not didn't appear in court.
Typically, you know, Shelby. Is that a typical case?
That was his decision, not mine.
It's always my decision. There's no litmus test except for the circumstances of the situation. The thing was, I felt that was.
It's a little grab that I don't know. Sure.
When did he, when was the bond, increase?
May 27th. 2026.
Yeah, it was because, it was, a date for a plea. According to the attorney, and he failed to appear. Thank you. Oh, it's not for him. Thank you. It's wonderful. Good things. That's why that bounced up.
That's why it's important as to.
There's always a reason. It's just a matter of figuring out what it is. Generally, I double it, but if there are other circumstances, and that's, I rely on representation. The attorney and the defendant, and then if they don't, you know, they can always change their mind, but they need to be present. Yeah.
You want anything else from that misdemeanor file? Judge? Do you want anything else from the misdemeanor file?
Been pleading on the intended case.
All right. Okay, Mr. Manning, what are you gonna do with that? From the defense side.
As far as today, I actually was making my question, tax, why, because if you can come back to Monroe and move back with his family,
Sir.
if he come back to Monroe and actually have his home confined in Monroe.
What am I, why?
You entered a condition on his bond of home confinement after his failure to appear on May
Whatever,
27th.
well, he's on home confinement, whatever his home is.
His home is here. His home is here, Judge.
Yeah, so if it's
why-
here, but I mean, if he moves to another home, that's okay with me.
Okay.
But it would be home confinement. But here's the problem is that I've got this motion now for an increase in bond, and I've got the information that's been filed that alleges a misdemeanor of assault on a family member, which is never. It's serious because if you're going to assault a family member, what are you going to do to someone that you don't know? And hold on, and this occurred on or about June 3rd is what this alleges. And this was filed on June 3rd. And what had happened was, we, yeah, unbeknownst to me, a week later, the defendant was here on June 10th. Right?
Not to my
2 weeks ago?
Not to my knowledge.
Well, um, who's that? No, since I've got 5,000 cases, I have to see on that date, it was set for that. And that was reset.
That's a notice based upon the motion I filed. It wasn't his appearance, Judge.
This case is reset on the hearing. Okay, on 6/10, when this case is reset for a hearing on 6/24.
They reset, they actually
He
set.
was here on 5/29.
He was not here on 5/27. He gets out on the new bond, alleged to have committed a new offense. I filed a motion to increase his bail on June 9th. The court on June 10th set it for a hearing today on that motion to increase. The logistics are, he now has a new lawyer who hasn't had any access to the discovery.
Well, we still, notwithstanding that,
Yes,
we're going to take up the matter of a bond.
Yes, sir.
All right, what are we going to do today, gentlemen, on the motion to increase the bond?
In our position, $100,000 bond, that was significant bond in this situation. You're reading about woman's wife, or they're going through a divorce. And these are just these allegations that she made, suggesting that she was injured with a wrist injury. I hadn't seen the medical records to support that, not saying that, anything didn't occur, but she's claiming that significant or some injury occurred. I believe that the $100,000 bond is, and also he's in a position where he wants to live at home, and he's now filing for divorce to get away from her. So I don't know if that goes to the issue. I know situations with her in the last 10. She's in a situation where she's basically trying to hurt him, with him not want to be with her.
What's that say?
Oh, no, like it.
This has been looked at by our office. I've actually talked to this complaining witness. The probable cause sets out the facts there. We've determined that there's more than sufficient evidence to move forward with the accusation. And the problem that we've got here is a man who has a criminal history, who's out on bond, who just recently got out on an increased bond, is alleged to have committed a new offense, and it shows a danger to the community, not only to Ms. Clark, but to anybody else. The theory that there may have been some divorce filed is insignificant compared to what the accusation. The bond needs to be addressed. $100,000 is not sufficient. It needs to be increased at a minimum.
Mr. Manning, what do you have? We kind of knew that all of it, but sometimes you get thrown into the game when you're warming up.
I believe that even with the $100,000 bond with him missing court, I believe it's custody under central discretion.
Yeah.
So, but I mean, we went from 10, I believe it was originally 7, and it went to 10.
There's no, yeah.
And then it went to 100. So
because that was the third time we had to increase it, right?
Well, I think
Judge, not to interrupt Mr. Manning, but I believe the whole reason why you increased it is you felt like 10 was insufficient based upon his criminal record. And then with him not showing, it just made matters worse. And that's why you entered the amount, Judge.
And what bothers me too is he's got an aggravated battery conviction, assaulted. It's assaulted of nature. And here we are on my watch when I have allowed him out on bond. He's accused. There's a charging instrument now filed with probable cause. that states that you committed another assault. You know, this dangerousness to the community is enough and probable cause to believe that you've committed a crime is good enough for me to raise your bond again. But and let's don't forget, you're a habitual offender. You've got no room for mistakes, especially assaulting, being accused of assaulting a girl. When I grew up, that was laughable. You don't assault girls, a man. Your bond is increased to $200,000. You understand? And the same conditions will apply. If you get out, you're at home, but you have no contact with any victim of a crime, including this. Then you have to have a GPS device, and you can't leave the house except for food, to see your lawyer, for medical needs in the most direct route possible. Anything else? You raised your hand. What do you want to say?
You know, get the accused, not the truth, but get accused.
Probable cause is enough for me to raise your bond, sir. You've the probable cause to believe you've committed another crime. And here's probable cause affidavit. Your attorney has a copy.
Yes.
Thank you, Judge.
Yeah,
He
and
may actually already have he should already actually have the GPS.
From the car. Yes.
and before he leaves, before he's taken in, we're gonna. Before he's taken to jail, I'm gonna test him to see if he's on any kind of controlled substance. What are you gonna do next, sir?
So we need to reschedule.
Yeah, you don't want to, is 2 weeks good? Something be done in 2 weeks, you think?
Yeah, with the issue. Sydney evening.
Really? 3 out of Louisiana?
You say you found this from.
Well, I mean, have Louisiana people ever try?
Yeah, that's why.
Fix it. Or-
He's gonna go back to the district
Yeah,
clerk.
so
Okay, it's fixable.
Yeah.
Just if you have a problem, talk to the staff. They can help you go through it. Yes, sir.
Judge.
Yes.
Thank you, Judge. I apologize.
That's all right.
I was covering for Bruce Smith this morning, Judge, on this true accident.
Yeah, that's it. I put a mark through that.
Yes, Judge, he was coming here from work as fast as he could. He's here, Judge. He was just, I think, slowly apologize to how it worked. I was asking for a reset on that case, because I know that you're going through some discovery.
Okay, his name and he wasn't here, right?
Yeah, I'll tell my hall to get a reset. It's based
Well,
on.
he's not, I don't care.
I understand.
That's okay. You're busy, but he's supposed to be here like he's supposed to be.
He's here, Judge.
Yeah, why is he late? Come here.
Sure. He was coming from work, Judge.
So
I want you to know.
that's, you gotta be here on time. I got a trial. I'm in the middle of we're about to start the punishment phase in the trial here in a few minutes.
Yes, Judge.
And that's why this works like a train station. You ever been on a train? If you're not there on time, they don't wait for you. They take off. That's the way it is. And then, look, this is a 3rd-degree felony of child grooming, which is about the most disturbing crime you can be accused of. And then he's got a prior conviction of illegal possession of controlled substance. It doesn't say what it is, but in 95, in this court, I was here, he was convicted. So if you're found guilty of this 3rd-degree felony, the punishment range is bumped up to a 2nd-degree felony if this prior conviction is proved, which means you're looking at up to 20 years in prison and you are not eligible for probation. That's how it is.
You understand?
So what's not in this, probable cause thing today, so is the age of the child. It says under the age of 17, but nowhere in the.
About 15, Judge.
I don't know. You tell me, so there's nothing that shows
That was her age.
a 15. Kyle. Any victimization of the child is never treated with happiness by this court, right? Should never be. What's the relationship to this
I
person?
believe it is his girlfriend's niece.
Last day.
Making sure you. You tell all files to make sure it's more the girl from Mr. Simmons. It's not mediation of the abstinence.
Okay. You had a copy of all this problem that was at the bank. It's all very disturbing.
And like I said, Judge, I can take up the file this morning.
I know, what's this bond? I don't like this at all. This is terrible.
Oh, yeah.
This is terrible. It's a 15-year-old child that you're alleged to have, according to this indictment, which you have a prior conviction, felony conviction, you don't need to be committing a crime.
25,000 condition, no contact. The victim or it's
Secretly sending money to the child, then purchasing items for the child discreetly without the parents knowing it. Then you told the victim you're sexually attracted to her, repeatedly requested sexual intercourse despite the victim consistently refusing and stating she was not ready. She's a child. How old are you again? How old are you?
55, sir.
Sir?
I'm 55.
55 years of age. Victim reported physical contact, including inappropriate touching of her leg. The family confronted you and told you to cease contact with the child. You later resumed contact, sending unsolicited cash monies and messaging the victim through social media and using a language that was sexual in nature. Digital analysis of your phone corroborated the contact. All of this screen reports messages, transactions, records, that's not pattern behavior, stick communication, business, emotional manipulation, sexual property, accident. Believe that you feel something conduct that could be later. That's what it's all about. Who does this to a child? What's the value of a child's innocence? $25,000? Well, no, it's limitless. Terrible. This is terrible. And what do we stand for? What do we stand for? And you got a fire conviction. You know that means that there's a big deal made about criminal behavior. Went through that and you were convicted and here you are. Now we're going to children, according to this. No, this is, I stand for the protection of children at the very least. These are vulnerable people. It's $100,000, your bond is up to $100,000. Plus, you have to have a GPS device. You're going to be at home confinement. Are you at home confinement now? Okay, you can go back and forth for work purposes in the most direct route possible. And you can go see your lawyer in the most direct route possible. So go get food is the most direct route and medical needs, but don't have any connection with children. And
Yeah, Tony, that's the bonds remain the same. There hasn't been an issue. There hasn't been a hearing.
I'm sorry, it was low in we're talking about a serious offense of grooming a child for sexual purposes. What do you think a bond is ever too low for that?
I believe a bond is
Or too high?
I believe it's to ensure his suspicion in court.
And the circumstances of the crime.
I understand.
He's around this planet is loaded with children.
I understand, Judge. I completely understand the conditions that you're
I
putting.
made my findings. It's what it was and do all due respect. Yes, sir.
So.
What are we going to do next? What are you going to set for next? What's your,
No,
what
I'm sorry.
are you going to do next?
Mr. Smith was asking for a reset to go through all the discovery, have more time to go through discovery with them. If it's just a normal reset.
Okay.
I believe he's out for the entire month of July, like typical. So.
Okay. This was indicted in February and they got no discovery yet?
He hasn't had a chance to go through all the discovery. I don't know what Mr. Smith's schedule has been, Your Honor, but if we can get just first part of August.
Yes, sir.
All right.
An initial. I want to say it's an initial, he was indicted in February and there was an initial docket in March 9th, reset to April.
It's just been sick. It was reset.
And then, yeah, it's reset to funds. Are you gonna handle this or is Ms. Shipley?
Bruce Smith is on this, Judge.
We got Mr. Shipley in here. We're in a whole bunch of trouble.
No, but, well, I mean, it's still Smith and Shipley.
It is, yes, Judge.
Oh,
I'm
okay.
filling in for him today because I was in the courthouse, Judge.
Okay,
Just my recess to take care of for Friday. So.
okay. Because I've seen her in here on behalf of Mr. Smith before and I just didn't.
Did you ask if she was law?
But anybody in the office, anybody in the firm, on his behalf is eligible to do it. Okay, reset how long?
Just early August is fine, Judge.
Okay, done. Yes, sir.
Thank you, Judge.
John?
Yes.
Yes, sir. Reset. And you got, hold on, you're sitting in the assembly box at
What time?
9 o'clock.
I thought, what time? Can you be here now? Oh, you
I
talking?
don't have to when I do that. Braden Hensley? Braden Hensley?
It's a set. We've got plea ready and Ms. Holmes asked if. Reset.
Who's got the plea ready and what are we gonna do?
Mr. Hall does, it's on tap.
Come on up, Willard. Let's take your matter up first. We're gonna take Willard. He's got a plea done. We'll take y'all up next. And who is this? It's Roy. Yeah. You Roy Batten?
Yes, sir.
Okay, we call 26 CR 606, the state of Texas versus Roy Thomas. Battle. Here with your attorney and the state's attorney, does the defendant waive a formal reading of the indictment and arraignment? Can we proceed with such?
Yes.
In summary, sir, this indictment alleges that on or about December 10th, 2024, wow, that was a while back, in Jefferson County, Texas, you committed the offense of operating a motor vehicle in a public place while intoxicated. Do you understand what you were charged with here, sir?
Yes, sir.
Paragraph, the other portion, the way it's written, paragraph 2, goes on to allege that prior to this event, in 2007 and 2013, you were convicted out of county courts at law of Orange County, Texas, and Jefferson County, Texas, for offenses of operating motor vehicle while intoxicated, DWIs. So 2 or more DWIs bump up a third charge to a third degree felony. Do you understand where you are sitting on this?
Yes, sir.
A third degree felony, if convicted, means you face no less than 2 nor more than 10 years confinement in prison, and a fine up to $10,000 can be assessed. Do you understand that?
Yes, sir.
An agreement has been reached in your case, you would be pleading guilty. And what? This says fine $250.
Oh, Judge, I'm sorry, I should have marked it. The sentence is 4 years, probated for 4 years. And
Is that right?
Yes.
and that's by agreement, Judge, that we're asking.
Okay, I'm going to put 4 here.
Thank you.
In this spot, 4 years, fine $250. And you can be placed on probation for up to 10 years. Do you understand?
Yes, sir.
If I follow this agreement, you have no right of appeal of your case. Do you understand?
Yes, sir. I understand.
All boxes need to be checked.
And we're going to waive the PSA.
How do you plead to this indictment charging you with operating a motor vehicle while intoxicated in a public place, sir? Guilty or not guilty?
Guilty.
Are you pleading guilty voluntarily and because you are guilty?
Yes, sir.
And those 2 prior convictions of DWIs out of 2007, 2013, county courts of law, Orange County and Jefferson County respectively, are those allegations true and correct?
Yes, sir.
And are you pleading true and correct to those allegations voluntarily, because they are true as they are alleged? So I'll show you what's marked as State's Exhibit 1. Here,
No.
Willard,
No objection.
did you sign that document? Understand them, discuss, understand the contents? Is everything true and correct there?
Yes, sir.
State's Exhibit 1 is tendered into evidence.
No objection.
Without objection, it's admitted. Among other things, this states you are mentally competent to enter your guilty plea. It's freely and voluntarily made. You know what you've been charged with? The indictment's been read to you. You've read it. You are guilty of the crime charged in any lesser included offenses. You have your rights to a jury trial and the rights to appearance, confrontation, cross-examination of witnesses. You're totally satisfied with the representation provided by your lawyer. All of this is true. It states so help you God. State's Exhibit 1 is made a part of the record without objection. Defense or state? Yes,
Yes.
done. Pre-sentence report is waived, right?
Yes, sir.
I'm going to follow this, stay on the length of probation.
Judge, it is our agreement and joint recommendation for the 4 years of probation. Mr. Hall has presented substantial proof that Mr. Bowden, from the day after this incident, has worked everything on his own to try to reconcile this issue. He's provided proof that he's attended AA from that day forward. Your Honor noted during the initial time frame the delay our office took with filing this matter. And I will say, out of the 36 years that I've been doing this on both sides of the bench or the bar here, I've never seen anybody take such extended efforts on their own. So I'm trying to reward that conduct in hopes that he continues it, Judge.
And Your Honor, I have a letter I'd like to present, that I wrote to Mr. Ham. It has 16 pages of AA meetings. And
This shows all that proof, Your Honor, that I just gave you.
he got out of jail on December 10th. December 11th, he attended his first AA meeting, and he has proof of that. And there's followed by 16 pages of AA sign-in sheets. His sponsor is here today. And he
What's
is
the blood specimen? Goes out? Mark?
Judge, that was 0.153.
Okay. Well, that's twice the legal limit. And what I'm looking at here is in the probable cause, what's really disturbing is the violent nature of a fight and attempt to be combative with the officers when they were arresting you.
Your Honor, he's accepting that responsibility as well. He's going to enter. He's going to enter a plea down the hall on the resisting arrest charge for a probation that's going to run concurrent with this as well. There's no doubt his conduct on that night was horrendous, which is the reason why I wouldn't go any further than what I've done on this plea bargain.
He's very ashamed. And he is part of the recovery community down in Mid County. He goes to AA all the time. He goes to a recovery church, and we have
All
letters.
that's great. All that's great.
It's great.
It's never too late, but this is the third time you were arrested and convicted of a DWI. So is this it?
Yes, sir.
For the, okay. One is too many, as you know. And we're here for three, and it's never too late to fix it. Just because everybody comes in and talks about how remorseful they are. I'll say that. And then a lot of folks come back. I'm going to follow this agreement. Okay. I'm going to find, and again, you are pleading guilty to this offense and true to the prior convictions in paragraphs 1 and 2, which constitute the third degree felony of operating a motor vehicle in a public place while intoxicated, 2 or more prior convictions. Based upon your plea of guilty and states exhibit number 1, there is enough evidence there that is admitted in these plea documents to support your guilty plea. To find you guilty beyond a reasonable doubt. I now find you guilty beyond a reasonable doubt as I find you mentally competent to enter your guilty plea. It's freely and voluntarily made. You understand and appreciate the consequences of pleading guilty. I hereby find you guilty of this third degree felony. I'm following this agreement. You are hereby sentenced to confinement in the institutional division of the Texas Department of Criminal Justice to serve a term of 4 years. That's 4 years in prison. I'm going to suspend that term of imprisonment and place you on probation for 4 years. There will be terms and conditions of probation here that the probation office will go over with you. And you will be fined $250 as well.
And Your Honor, the state is willing to allow him to attend weekend time in jail for 10 days.
That's correct, Judge. I don't want him to lose his job.
Well, that's a risk you take when you do this, right?
Yes, sir.
How are you employed?
So,
How are you employed? What do you do? What kind of work do you do?
I'm a welder.
He builds tanks. He works inside of confined
But how much do
spaces.
you make an hour?
I make $33.
Yeah. Well, that's $70,000 a year. I mean, that's a fortune to a lot of people, which could lose either by flirting to trouble. Right. Under these terms and conditions of probation, there are 36 terms and conditions of probation. Most of these are the terms and requirements that I have to follow every day. So, you will be ordered to serve 10 days in the county jail on successive weekends, beginning when? You all report on or before 6 o'clock PM each Friday.
Yes, sir. As soon as possible, next weekend. He's from July.
July 3rd.
So it's July 3rd. Yes, July 3rd.
Beginning 7/3. So also must have an auto ignition interlock system installed in any vehicle, and you will complete the Texas DWI offender program, which is what you need to do, but also it will help reduce and mitigate the cost of insurance that you get hit with for something like this.
Yes,
So it'll mitigate that penalty that you're going to face. Okay. You understand what's happened today?
yes, sir.
Okay. If you fail, your probation could be revoked and you could be sentenced to 4 years in prison. Please see the probation officer and
Thank
do
you.
well. Thank
Thank
you.
you, sir.
Yes, sir.
Your Honor, yeah, Coach.
Yeah.
Mr. Williams did show back up and he did test and then got the results back right there. Ellie has it in her hand.
It must be good for you.
They are, otherwise I would not be.
Yeah, I didn't.
Yeah. So we can
Okay.
get her 4-week resetting.
Yeah, get a resetting.
Get resetting and good to go.
Here's this one. Who's next? Yours?
We just need a trial setting.
On who?
Lorenzo,
Who?
Lorenzo, that's when you get called earlier.
Where is he?
He's.
Come forward.
I'm gonna give them all. Yeah, so.
Okay, 25 CR 863, you are Lorenzo Walker.
Yes, sir.
You're charged with the second degree felony with aggravated assault, causing serious bodily injury by striking the victim in the face with a piece of lumber, which caused serious bodily injury apparently. And so the victim was transported to the hospital in critical but stable condition, including multiple broken facial bones and loss of teeth. Well, that can't be good for the infant. Thanks. So, no. What caused, is that what you do normally? Is that no? You have to speak out so she can take everything there. You're shaking your head. That doesn't count. You have to speak out. Did you know this person?
Yes, sir. I didn't know.
Okay.
See you there.
This is at 2:12 in the morning. Never anything good really happens about then. What's that saying on, what are we doing? Hey, Willard.
We've made an offer, they've rejected it, Judge.
This goes into Mr. Don. Okay. You're asking for trial.
Yes, sir.
Let me just say this, you can't have any contact with the victim. I find out you do, you'll sit it out in jail until we can get around to it. And no one on your behalf tries to influence the victim. You understand?
Yes, sir.
If I find out, I just found out the other day about somebody and they're gone. They're sitting in jail until we can get their mess fixed. But serious injuries like that, generally, it's not proven that they beat themselves in the face with a stick, with a board. Generally, somebody caused it, and the grand jury says it's you. All right, anything else to add? Let's get this thing to trial. It sounds like this one could be quick. Let's move it fast track it. Thank you.
Sure. Thank you.
Next. Who's up? Who's left?
We have a
Forgot to write,
Okay.
reset on yours. Justin Walker has a new attorney and I reset it. Quick turnaround for that one. And I think I already put the file, maybe, you know.
There's Justin Walker.
Okay, I think Bernie Williams too, we still have.
Okay, on Willard, we took care of Willards?
Yes.
That's right.
Okay, I have,
Oh,
give you that, and Lorenzo Walker, we just took it to that. Okay. Then I have. Inslee. And Elia Martin, what did we do on that?
it's an initial setting.
We haven't dealt with that one.
No,
Justin Walker,
reset, you already had it. And I had Bernard Williams.
David Davis.
That's the add-on that you asked me to bring to court today.
Okay, we still need to that. I have Vernon Williams.
I need that one.
That's been done. Okay, yours is
Braden Hensley, Your Honor.
Hensley.
And
Come on up.
I do have one additional witness in addition to the defendant. So.
Okay, hold on. Let me get this set here.
Yes, sir.
On 24 CR 515, the state of Texas versus Braden Hensley. That's you, sir.
Yes, sir.
Present with your attorney, Mr. Wilkerson, the state's attorney. And earlier you entered a plea of guilty to the third degree felony of illegal possession of child pornography. Is that correct?
Yes.
And that was done, is that May 18th, last week, month? A pre-sentence report has been prepared. Have the parties had an opportunity to review it? Are there any corrections or changes to it?
None from the defense, Your Honor.
None, Your Honor.
It's been made a part of the record for all purposes. Okay, what did you, how did you want to proceed on this?
Judge, I have two witnesses, one being the defendant himself and one being the defendant's mother. I don't know if you want a question here at the bench or have a seat at council table. And
We can do it here.
okay.
Where's his mother? Okay. Why don't you exit like we do on witnesses under the rule of sequestration? Because I don't know what she's going to say or he's going to say, but we don't want to have a risk of, okay, I heard what he said, I'll just say what he says.
Yes, sir.
All right, raise your right hand, sir. Do you solemnly swear or affirm any statements you make during this hearing shall be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
Lower your hand. Go ahead.
Mr. Hensley, the offense date on this was April 4th of 2023. Is that correct?
Yes, sir.
November 4th.
That was November 4th.
I'm sorry, November 4th of 2023. Prior to that, you had been on probation in Hardin County. Is that correct?
Or,
I was,
It's in your PSI, Judge.
I know.
I'm sorry.
it was possession of controlled substance.
We're gonna let him do this speaking. You'll listen.
It was possession of controlled substance and burglary.
What was the controlled substance?
It was ecstasy.
Mhm. Where were you acquiring that from?
Just this, it was a dude I went to high school with.
Keep going.
All right. You were required to go to ISF.
Hold on. Before we. What about this 5 years probation for burglary of habitation? That was at the same time.
Yeah, they both gotten combined, I guess, because of COVID. That's when both of them,
That's when those were disposed, they were disposed on the same date, January 23.
Yes, sir.
And then you were revoked, sentenced to 3 years imprisonment on June 5th of 2024.
Yes, sir.
Why were you revoked?
Because I couldn't, I kept.
Of this case?
Sir.
Because of this case?
No, sir.
Oh, because that would, that could have worked, but under the timing of it all. But what were the reasons you were revoked?
I was revoked because I kept failing my UAs for alcohol. Yes, sir. And then I had went to ISF. I had come home and then
no sooner or later I came home, I bailed another UA for alcohol. Then got my probation revoked, went to TDC, and that was I don't know, that made me realize my freedom and how much my decision making was back then was, I mean, it just was, it's very poor. And
You were you abusing alcohol severely?
yes, I was.
And was that disinhibiting? You weren't considering consequences of your actions at the time?
No, I was not.
How old are you right now?
23.
Go ahead.
You were then sentenced, as you indicated, to 3 years TDC. Tell the court what you learned from that experience.
So I just learned that all of my consequences always have actions. It doesn't matter what I'm doing right then and there. I always have to worry about in the future, and not only who am I affecting, me myself, just the other people around me. I've learned that's just me as a person. I'm trying to work on it, and that going to TDC and coming home, and now
How long were you in prison?
I was just a little bit over a year and a half. So
Since then, you've been on parole, is that correct?
yes, sir.
Have you experienced any problems with parole?
No, sir.
Just before you went to TDC is when you were arrested on this case, is that correct?
I wasn't arrested on it. That's when the phone was discovered with my old job. And as I was awaiting to go to ISF, that's when I guess it went to.
This case was indicted in March of 2024, to the best of your recollection, is that correct?
I thought it was at 23.
Well, so the offense date was in November of 23, right?
Yeah.
When the phone was picked up and you were waiting to go to, you said that was ISF at the time, right? The phone was discovered when you went to ISF.
Yes, sir.
And then you came back, you messed up, you went back to prison, correct?
Yes,
Did you post a bond in this case?
I did. Yes, sir.
And so that only gave you 2 days credit, is that correct?
Yes.
And so while you were on bond is when you served TDC time on your Hardin County offenses, is that correct?
Yes, sir.
All right. Now, with regard to the nature of this offense, do you understand the severity?
Yes, sir, I did.
Can you tell the court in your own words, in terms of victimization, what you realize now that didn't seem to strike you back then?
Back then, I guess I just had my not necessarily. I mean, it was fantasies. I guess at the time it was kind of twisted. I didn't realize the way I see things now is. I mean, I don't want to bring it up here, but I will. I have a 4-year-old sister now. I look at her as as she's my own daughter. I mean, I could never imagine anything that ever happening to her. And if it did, I mean, it would really affect me. And I just know that this right here is, I know it's a speed bump. It's something that, I've done. I don't know how else.
In this,
I hate all of it. I want to just, I apologize.
In this case, you understand that the court has a number of options, correct?
Yes, sir.
You understand that whether you are sentenced to TDC and later paroled or you're offered probation here, you're going to have to comply with sex offender terms, including registration.
Yes, sir.
Do you understand why the court would have concerns about you being around your sister unsupervised?
Of course, but she would never be unsupervised. My mom and her father, my stepdad, is always there at the house, or she's at daycare during the day. So,
and do you understand that one of the things that the court could do is send you to home confinement for a portion of probation, or you understand that the court could place you outside of your home until your counselor and completion of chaperone training by your mom and your stepfather was completed in order that all proper precautions were taken.
Yes, sir.
You talked about, having a sister now and imagining something bad happened to her. In terms of, is that the way that you have personalized the victimization that the kids in these other images?
I think anybody, if they had a picture of my sister, that was any sort of way that's wrong looking, I think that is the most, I realize that now, that is the most wrong thing. It's sick. It's just messed up.
Oh, wait. Well, what caused you to have a feeling of that now? You didn't have a problem victimizing all these children in these pictures then. I mean, they're children, like your sister.
Mhm.
Well, why couldn't you see a comparison? Why didn't you have empathy for them then?
No, I wish I had an answer for that.
That doesn't make sense to me.
I see her now, and it's been an eye opener these last almost 5 years.
The use of alcohol in your life, did it numb?
Yes, it did.
Was the alcohol voluntarily taken?
Yes.
Or did somebody force you to drink?
No, sir. No, it was
Okay.
voluntary.
All right.
Would you agree that you have had a problem with substance abuse?
Yes, sir, I have.
Would you agree that much like addiction, these issues, if not treated properly, can rise again?
I think they could, yes, but I don't.
You don't foresee that happening?
Not in this situation.
You understand that sex offender conditions could include prohibitions from being online, limitation on the kinds of phones you can have, and you understand that there can be polygraphs taken during probation sessions, and that you would have to attend sex offender counseling.
Yes, sir.
If you would not have made bond in this case, you would currently have some time. You said you spent about a year in TDC, is that correct?
Yes, sir, about a year and a half.
Before you paroled out?
Just 1 second, Mr. Fuller. Can you tell the jury we're going to need just a little more time? Thank them for their patience. 10 or 15. Thank you. Go.
And so, if you had not bonded out in this case, you would have about a year and a half back time at present.
Yes, sir.
But because you were on bond, no time accrued toward this case, correct?
Yes, sir.
Yeah.
No idea. I just walked in. But
Yeah, find out what they need.
Okay.
Because I got a jury out there.
You also have the guy in jail we need to deal with.
In terms of, you've talked about putting who you were in your past behind you. You talked about putting who you were in your past behind you. Tell the court about your efforts to essentially to rehabilitate yourself and what your life has been like over the last 10 months.
I've been employed this entire time, so I'm trying to work as much as possible. Just completed my first semester at Lamar State College in Port Arthur for audio engineering. So I am trying to work on my education and just try to stay focused and, not get involved with drinking or smoking or anything that I was involved with in the past. I really am. I have been since I've been home, trying to give my life a second chance.
And with regard to that, trying to give your life a second chance, as you suggest, you've had no problems while you've been on parole. That's correct. All right. And so we're looking at
Do you understand that the court could also sentence you to up to 7 years in conjunction with our agreement?
So
Are you asking the court to, in part because of the time that you've already served that hasn't counted toward this case and based on your efforts that you've described, to give you an opportunity to complete sex offender counseling and be placed on community supervision?
Is he doing any sex offender counseling now?
At present, not that I'm aware of. Your Honor.
Okay, go ahead.
And would you comply with all terms that the court would order for you?
of course, yes, sir.
And is that reflected, do you believe, in how you've handled parole since you've been out this time, since you were discharged, since you were paroled out?
Oh, yes, sir.
Was seeing prison enough to set you straight, so to speak?
Yes, yes, it has.
I'll pass this for you.
Anything from Sam?
Oh, I've got a few things.
Go ahead.
So since you're under oath, let's start with what steps have you taken since you got released to address these issues that you're asking the court to deal with? In other words, what have you done on your own?
Just going to school and working. I mean, I haven't done any sex offender classes or anything like that.
So you haven't addressed that issue yourself, right?
No, sir.
No, but you're asking and you're relying upon the fact that you're going to go ahead and do that if this court grants you probation.
Yes, sir.
Yet you've been out of custody for how long?
Just a little bit over a year.
Over a year. Over a year, you have not addressed the problem on your own.
Yes, sir.
All right. Number two, I want you to recognize that the judge did you a great favor in asking your mother to be absent from the courtroom. It's going to allow me to ask you some questions about the information that's on your phone. I'm prefacing that before we get started. You and I both know what's on there.
Yes, sir.
The court has read some to some degree, but it's not given the detail of what actual pictures you were taking of your mom. Your mom is here to testify as a character witness for you. Is she aware of the information that you have on your phone?
Not about her, but
No, I want to know specifically about her. Does she know what kind of pictures you were taking of her?
She knew that I had pictures of her, not today. No, sir.
Are you prepared for her to hear that? Because if she testifies, I'm going to be telling her about that.
Yes, sir.
All right. I'm going to give you a chance to tell the judge what's in this deal that not only one of the witnesses provided in discovery, but an officer detailed in his report about the images you have of your mother. Go ahead and tell him.
I had pictures of my mother just around the house.
Be specific, sir.
I had stolen her underwear at times. Did acts with her underwear. Yeah.
He's a big person. He knows what he knows the words. Tell him.
I ejaculate on her underwear and sneaking behind her, taking just pictures of her. Yeah, it was like a sexual thing. Yeah.
And when was this?
This is all.
What period of time are we talking about?
So this would have been during high school and just a little bit right after.
This is you're charged with this offense on or about November 4th of 2023.
Yes, ma'am.
When in relation to that date were you doing this? We're talking about with your mom, as using your mom as a fantasy tool.
Up until about a year before that whole time until I got everything came out.
And all those things were at least occurred during the time in which you were on probation.
Yes, sir.
For two crimes.
For two crimes. You had over 100 images of you with videos of you masturbating, ejaculating on your mother's underwear, specific videos of you masturbating in the back seat while she's driving,
Yes.
all under in a work phone underneath a folder labeled mom so that you could have easy access to know what that was to continue your sick fantasies.
You have to speak
Yes,
out.
yes, sir.
Okay.
Yes, sir.
And you've never addressed that, yet you are relying upon this court to the suggestion that he could give you probation and send you to live with her and your sister that you're describing as someone that you really love and care for.
Yes, sir.
Do you not love and care for your mother?
I do.
Do you not see the problem here?
Yes, sir, I do.
Well, why would you victimize her if you love her? That's kind of hard to put together, isn't it? You don't victimize somebody, you care for them.
Sir.
Oh,
Last thing, Mr. Hensley, when you were talking with the judge, you described all of this as a quote unquote speed bump. I will give you one more opportunity to change that answer.
Yes, sir. I was a sick and twisted individual growing up. I had a lot of bad, inappropriate pictures that I had found on Google. It was definitely not a speed bump, just
bad choices,
horrible choices. Yes, sir.
but choices
that
nonetheless.
I made.
Choices you made, you've continued to, up until today, to try to minimize it, describing it as a speed bump. You tried to minimize that contact when you talked to this PSI officer just a few weeks ago. And you think we should trust you to send you back to fantasize some more about your mother and whatever God knows happening to this poor 4-year-old sister of yours?
No, sir. I would like to have some supervision or classes that I can take because.
Yet you've done none of that on your own.
No, sir, I have not.
I have no further questions of this witness.
Anything else?
Mr. Hensley, how old were you in November of 2023?
I would have been 21.
Yeah. And you said that this continued up until about a year prior. Is that correct?
Prior and yeah, until right before that.
I believe in your PSI, you stated that you started collecting images as early as middle school. Is that correct?
Yes, sir, I did.
And in conjunction with, well, first of all, aside from some counselors who work with probation departments, have you? Well, strike that question.
What's next?
Are you asking this court to intensely supervise you for the best interest of the community to ensure in part that these types of acts are no longer being committed?
Yes, sir.
While you believe that these issues would never arise again, would you agree that for the safety of the community, it would be best for that to be verified in some way through sex offender counseling?
Yes, sir.
That's what.
I don't have any other questions of him.
All right. Anybody else?
Yes, I'll call Carrie Marchand.
Who is that?
His mother.
Okay. Have a seat right over there, sir. You like front row, first chair. Thank you.
She has been, she's gonna say, oh, I'll be nice.
Come forward, please.
I remember we talked about this.
Oh, that's not great.
You're going under oath.
You're always welcome. You know that.
Thank you for saying that.
I didn't know if you were thinking we're in a hearing, but you can always come always, anytime, as you know. Thank you for doing that. Come forward, please. And raise your right hand. You solemnly swear or affirm any statements you make during this hearing shall be the truth, the whole truth, and nothing but the truth. So help you God.
Yes.
Lower your hands. Go ahead.
Spell your name.
Spell your name.
Spell my name?
Yes, ma'am.
My first name is Carrie, Carrie. Last name Madishon, Madushan.
Okay.
You are the mother of Braden Hughes, correct?
Yes.
I want to get one thing that's probably pretty uncomfortable out of the way now. Did you have an opportunity to speak with detectives after the materials were discovered on your son's father?
Yes, one of them called me.
And what did that detective disclose to you with regard to images on the phone that may have involved you? Or were you made aware of images on your son's phone that may have involved you?
He told me that there were images of young women.
Did he
That were on, he said that were on there, images of young girls.
Did he ask you if you wanted to press charges at any point? Or were you asked about that at any point?
He said there was a video of me on there, in a pair of shorts, and asked if I wanted to press charges for that, and I said,
okay. So you're not fully aware of the context of the images that were on.
I never saw them, and he didn't disclose anything because he said that was evidence, and he didn't tell me that. All I know is he said that one was about a year prior, and then the rest of them were from earlier than that.
All right. You understand what your son's charged for, correct? And you understand that whether it is conditions of probation or conditions of parole at some point, that the court has concerns about him being around his 4-year-old sister. And if the court were to order,
Actually, I'm concerned about any child.
I intend to address that, Your Honor, but and so if the court were to order that your son be placed outside of the home, at least until such time as you and your husband could undergo chaperone training, would you be able to support your son in that context?
Support? What do you mean by support?
In other words, would you be able to contribute to him having a residence outside of the home if that were necessary?
Help him pay rent and things like that? Is that what you're asking?
Yes.
That I don't know. I'd have to sit down and we'd have to figure our finances. My husband and I are we're wanting to buy a house come December, January, so that will put in there. It's not a thought that I've had.
Okay, let me ask you, do you understand why, with images of young children, there would be concerns about him being around any children?
I wasn't aware there were images of young children. I thought they were girls that were about his same age at that time.
What do you mean by about his same age at that time?
Around, because this was 3 years ago, and almost 3 when I was talking to detective.
Adults, other adults, young adults.
Yes, and Braden's, he was 21. He had just turned 21. And he said that one image was from the year prior, over about a year, almost January of the previous year is what he said.
When you
And then that puts Braden at being 19, 20. So I'm thinking about, I know of one image I saw on Braden's phone accidentally because we had the same type phone, and I accidentally took his phone to work one day and he had mine, and his girlfriend at the time, who was a year older than him, he was 16, she was 17. she was an aspiring photographer and she liked to send him pictures, and I saw one.
And so was it your belief that all the pictures were of that age?
Yes, yes. Her and her friends
So,
sending him pictures. And I spoke with her mother and stepdad. Hope to try to end this, but
so, you're not aware that there were images that are described as being with children anywhere from 5 to 10 years of age?
no, don't know anything about that.
With regard to such an offense, are you still asking this court to be lenient with your son and give him some sort of community supervision?
Yes, because I don't feel when Braden is with my daughter, her name's Amaya, Amaya. They're like brother and sister. They play, they do their fist bumps, and Braden's always been an artsy kind of person, like paints and sketching and drawing, and they'll sit at the table and color Pokemon, and he'll take her out and ride bikes, and it's just typical. And they banter back and forth, and he'll pick on her and she picks back, and I don't feel any kind of weird vibe going on there at all from him. And if she's ever in the bathtub, and I pull the door closed, he never, nothing. So I don't have any discomfort there at all.
I can appreciate that. I'm just going to say right now, there are some things you don't know.
I understand that. I understand
We know,
that.
and they're most disturbing.
But I was asked how I felt.
I
And
understand,
that's how I feel.
you seem like a very nice, wonderful person.
Oh,
This court just doesn't tolerate the victimization of innocent people. And who does, really,
Right.
reasonable. And this is going to get more disturbing as you stand there. I'm afraid.
can you tell the court what growth you've seen in Braden since he has been discharged to parole?
He is a different person than he was in his late teens and early 20s. He has a job that he's been working for now for a little more than a year at Nebraska's. He started out as a dishwasher. He's promoted now up to fry cook. Got pay increases. He works nearly a 40-hour work week every week. This year, I have another son who's 2 years younger than he is. Started school this spring, and Braden expressed an interest in studying some music classes. So with that, I encouraged him, and he signed up with Lamar State College in Port Arthur. And he took 2 classes, and one was an online class. Braden's not the best with reading, and so he kind of stumbled with that, but he still tried. And he had the other class, which was an American music class that he'd go to Tuesdays and Thursdays. He was there every day.
When you say he's a different person, though, what do you mean by that in terms of changes that you've seen from before prison to after prison?
Before he had to go into prison, he was a little reckless with himself. He got involved with marijuana and drinking, and just a little stupid, crazy. It's the best way that I can explain it.
Just once he was put on probation the first time, and continued, I guess, down this alcohol path. How did you address that? How did you provide support?
Well, in 2021, when Amaya was born, she was born in August. That Christmas, Braden was drinking I got a little carried away with this drinking and alcohol. And it was pretty much the boiling point at that time, and I made him leave the house. Basically, my husband and I, we kicked him out of the house because it was a behavior that I didn't want to be around, he didn't want to be around, and I didn't want it around my newborn.
Your other children?
Well, and my other son had moved out and was living with his girlfriend, so it was just 4 of us. But it was primarily, you know, I don't need this influence, this behavior. You're over 18, you're grown, you need to be,
So,
take care of yourself. I can't
so-
do this for you anymore.
so is it the case that you don't put up with intolerable behavior?
Yes. I mean, I can excuse some, I can make it excuses, I can rationalize it. But when you constantly just keep doing the same behavior over and over again, I couldn't deal with it anymore. You know, he was yelling, he was screaming, we had people there, it was Christmas.
And would you say that that type of behavior was pretty much the norm for him prior to going to prison?
It was like, it wasn't his norm all the time, his whole life. It was just where it had come to a head at that time. But yes, it got to the point where I made him leave the house, and he was basically homeless for almost a year.
And so, do you know what chaperone classes are?
No.
All right. And so do you understand that if, that whether Braden's put on probation or he receives a sentence and then is later, paroled out, that there will be conditions on where he can and can't live and who he can and can't be around in terms of age?
Well, I understand.
All right. And, are you willing to complete whatever programs are necessary to ensure that you are properly supervising your daughter around someone who will be a registered sex offender?
Well, yes, of course. I mean, yes, of course.
And in terms of Braden, right after he was arrested on this charge, he is when he went to prison. Is that correct?
Right. Probation violation.
And that probation violation was at the continued use of alcohol, even after ISO.
Yes.
Is he using alcohol these days?
I do know that he has, but it's rare. It really is. But that he works and he's late. He gets off late in the evenings, and I'm not always awake when he gets home from work. But as far as I know, it's rare. That's all I can say. I know that he has.
Does Braden show an interest in wanting to be a better person than he used to be?
Oh, yes.
Or that his behaviors, let me say that his behaviors tended to demonstrate?
Well, when I was speaking about him going to class, he really enjoyed taking those music courses. He bought his brother's car because he was wanting a car, so he bought his brother's car. His brother was trying to save money for a trip he was wanting to take, so it was twofold. Brother got money, Braden got a car. But the car's a 2010 Kia Soul, and it needs a little work on it. So he's been learning basic mechanics to fix up his car. And he has expressed to me that he actually really enjoys doing that.
Yeah.
Which I'm happy for. Anything that says, hey, I like doing this, I like working on that, I'm going to encourage all that. I mean, that's just me as a person and me as mom too. I want to see him happy. I want to see him succeed. I want to see him moving forward with his life, finally growing up and becoming the adult that he should be.
Do you think that's happening now?
I believe he's finally on that path. I really do believe he's on that.
Do you think it would be in his interest as well as the interest of others to be supervised and continue a pathway of counseling, sobriety, and growth?
I don't see where that would hurt.
Are you asking this court to, in part because he's already served some time that's not attributable to this case and because of his support system and the changes that you've noticed in him to be lenient with him and grant him some sort of community supervision?
Yes.
Passed away.
Let me just ask you, what about drugs? Are you aware of him
I know he
misusing drugs?
vapes. I know he has a vape, but as far as anything else, I don't. I'm unaware.
You don't know?
I don't. I'm unaware. I haven't noticed the behavior that I noticed several years ago, where he would be slurring speech, constantly consuming any kind of sweet goody, Libby was his best friend kind of thing. I haven't seen any of
Okay.
that. He's gained weight. He works. I mean, whenever they call him, even if his day off, he'll go to work. And I know if I need any help around the house, he's there. He's there to help.
Okay. Go ahead, Steve.
Thank you, Judge. How long has Mr. Hensley been back?
Since he's been released.
From prison?
It was, I want to say it was March of last year
And that time frame, he's living where?
with me and my husband and our daughter. And
And
now my son's moved back in.
so have you had any structured supervision restrictions placed upon him?
I just like to know where he is.
Has he had unsupervised access with your daughter?
Unsupervised, like babysitting.
Has he been alone with your daughter?
No, because my other son, I've left her home, like if daycare was closed and my husband and I had to work, it's both sons were usually there sometimes. So I don't remember that he's ever been there by
Are you
himself.
certain?
Not 100%.
Are you concerned?
I'm not concerned, no.
Okay, let's talk about that then. All right. What is the charge that he's here for?
Possession of child pornography.
What does that mean to you?
Well, I know what it sounds like, but for me,
Not what does it sound like? I'm asking, what does it mean to you?
To me.
Yes, ma'am.
for me, it means that he had pictures of young women. That's what I,
Define young women for me.
around his age, 16, 17, 18.
That is not child pornography. You're telling me that whenever you listen to things on the news and you hear about people being in possession of child pornography, every one of those times
No.
you've thought it's just young adults?
No, because
That's because that's not what it is, man.
I understand child being someone under the age of 18. That's the way I understand the child. And some are and some are not. Small children and some are not. Some are.
Your son, when he was interviewed, said, I have thousands of screenshots from middle school. They were underage. They were 5 to 10 years old. That's where your lawyer or his lawyer was getting the concept of 5 to 10 years old. He has he has an unaddressed concern for pictures of young children around the age of your daughter. Does it change anything? Now that I've told you that, and I'm just beginning to scrape the surface of what's here. Does it change any of your concerns? Are you concerned at all now that I've told you that?
With relation to my daughter, no. Because I just don't see anything.
All right, so I want to time out there for a moment.
Mhm.
What the lawyer for your son has pitched is that this court ought to consider giving him probation, which means sending him back home to where you live
Mhm.
with that child, and you still don't have concerns about him being around her.
No, because when we buy our house, both of my sons won't be living with us. No,
Ma'am, that's not enough.
I really don't. I mean, honestly, I don't, not with regards to my child. Even hearing this, because this is the first time that I'm hearing.
We're going to get into some more disturbing matters, ma'am,
Okay.
because you've been labeled as part of his support system. And I'm going to be fair with you and tell you that before you were called as a witness, I gave your son an opportunity to tell you what is on this phone before I do. And they chose not to do that. They just called you in here. So that means I'm going to be the one that gets to tell you what's on there.
Okay.
And it's not fun. So two different witnesses have detailed the fact that on his work phone, not a personal phone, on his work phone, he had a folder labeled mom to where he could access photos of you. Those photos were sexually inappropriate.
Stand by. I'm going to mute this part.
Thank
She
you.
doesn't deserve it.
Just to address all that for, right?
I suppose, yes.
No further questions.
Anything else?
Hearing the things that you've heard, can you ensure that he would have no unsupervised access to his sister, whether that was ordered or not?
Absolutely.
And you understand that if he is granted any form of probation, or even later if he's granted parole, that will likely be a condition.
I understand that, yes.
And are you still asking this court to allow him to go into treatment and those services be provided to him through community supervision?
Yes. Because I really would like to see him get some sort of therapy, treatment, education, whatever. I mean, anything that would benefit.
Nothing has prevented that from happening.
I wasn't aware of all the.
No, he's a grown up.
Exactly.
No, that's what.
I don't have any other questions for her. She's been
Who's
victimized
next?
enough.
Anybody next? Anybody?
No, sir.
All right.
No, sir.
Come on up, sir. You may be seated then.
You don't have to leave the quote. You have to sit down.
The pad?
Yeah, charge it.
All right, before we finish this up, let me ask you, you were on probation or in 2 cases in Hardin County for illegal possession of a controlled substance. What was that?
It was ecstasy.
I'm sorry, ecstasy.
Ecstasy.
And then you were on probation for burglary of a habitation out of Hardin County. Whose home was burglarized? Anybody you know?
It was my grandmother's.
You burglarized your grandmother's home. Is that right?
So
And you were placed on 5 years deferred or unadjudicated probation on each case on January 26, 2023. That was revoked 1.5 years later. Both of those, and then you were sentenced to 3 years in prison. For what reasons were those 2 probations revoked?
I kept failing my UAs whenever I would report for probation.
Okay, you were failing your UAs. What were you testing positive for?
Alcohol.
Okay. Sure, we're not missing anything. Do you remember being interviewed by the probation office for this case?
Yes, sir.
Do you remember when that occurred, when you had the interview with the probation office?
Yes, sir.
When?
It was about 2 weeks ago, 2.5 weeks ago.
2 weeks ago? Okay. So other than ecstasy, any other drug problems?
It was drug. It was ecstasy, marijuana, and alcohol. Those were my.
Okay. How long were you using marijuana?
Up until I was on probation.
How long? I don't know what that means.
2022.
When did you start?
January of 20. Oh, I was 15. In
Okay.
2017.
9 years,
Yes, 9 years.
8 or 9 years?
Yes, sir.
Where were you getting your marijuana from?
Just whoever I was going to school with, friend, buddy.
And how frequent was that?
It's probably like once a week.
Weekly for 7 years?
Yes, sir. Yes, sir.
Did your mom know about that?
Yes, sir. She did.
She knew you were using marijuana weekly, committing a crime every week, 52 weeks a
Yes,
year
sir.
times 6, 7, 300 times?
Yes, sir. That's why she kicked me out of the house.
When did she, after 6 years of finding out that?
Yes, sir.
And nobody, so y'all knew about problems here, but you didn't go treatment for that, right?
I just. No,
You're
sir.
committing a crime each time you do that. That's 300 some odd crimes. Okay. You're free falling. This is just free falling in all kinds of ways, isn't it? Oh. If nothing further, earlier you pleaded guilty in this case voluntarily. You were mentally competent to do so. You understood and appreciated the consequences of pleading guilty. There's sufficient evidence supporting your guilty plea from State's Exhibit 1 admitted here to find you guilty beyond a reasonable doubt. And I now find you guilty beyond a reasonable doubt of this third-degree felony of illegal possession of child pornography. And again, these are crimes. This is a crime that is alleged to have been committed after you were placed on probation in two felony cases out of Hardin County. And you made promises when you were on probation that you would follow the rules. The first rule in all probation terms is do not commit other offenses. And so you are charged with committing this on or about November 4th, 2023, after you had been placed on probation in those two cases. Then your probation were revoked for what reasons again? It wasn't for this illegal possession of child pornography, was it?
He
It was
states
something else altogether.
failed UAS is what he's
Yeah.
saying, Judge.
Yeah, you were failing the drug tests, so they revoked you for that. Illegal possession of child pornography is just not a simplification of a crime. It's not simple. Every child image portrayed in any image is a victim of that. And we are talking about multiple victims of children. Plus, we know now you even go so far to victimize your own mother in this. Yeah, you need some help. But this is something that you should have received help for a long time ago. Not here, after you're placed on probation in another case. And you're still, on the one hand, trying to make amends for the two crimes you were placed on probation for in Hardin County. And then you're on the other side committing crime all the time at Ailey for the child pornography. I don't feel sorry for you. I feel sorry for these children. That's who I feel. What is the price of the innocence of a child when they are victimized in pornography and then that pornography is possessed or traded or used? That child is a victim over and over and over again. What is the value of the loss of innocence of a child? You can't put a price on it, because I've got 2 children and 3 grandchildren. I couldn't imagine the harm. But I've done this for 20 years. I've been a lawyer for 40 years, and I've dealt with child pornography. It is maybe the worst, because children just, when they're victimized, they have a hard time ever becoming what we want in a normal life, because it haunts them forever. It's not something you can just shrug off and forget about. You used it for your prurient pleasures. That was terrible, sinful crime. I now find you guilty beyond a reasonable doubt of this third-degree felony of illegal possession of child pornography. I am following this agreement. You are hereby sentenced to confinement in the institutional division of the Texas Department of Criminal Justice to serve a term of 7 years. This seems like that's not severe enough for what you have pulled in crimes. This is now your third felony. It's a different type of felony, but this one is innumerable children and family have been victimized by you. You need to fix that. You can fix it on your own if you want. I don't have to force you into probation. You'll be paroled soon enough. The parole authorities hopefully will work with you. But at the end of the day, all of this is your choice making. You're going to decide what kind of life you want to live for the rest of your life. Is it going to be atonement and trying to do better? Or will it be continuing to fall back on your prurient interest, which victimizes others? This is a simple choice to make. Do the right thing. You can start anytime, but do it and stay on the path. But you have victims that you have to pay for. And that's what this is all about. That's what we call justice. That is all. What else do we have? John, did you have something?
Oh.
You said it for trial? Okay.
No. You're here for the trial.
Okay, I thought you had another case you were working. Okay, what do we have here?
Jared is covering for Haley Simmons. It's that the memo we need to do for the guy that was in custody to get the scram device. We wanted him brought here. We were going to release him so he could have 24 hours. To
Okay,
get the scram,
good.
but you said bring him here. You put it.
Where is he?
He's in jail. So
Okay, I just,
can I just do the memo?
yes,
Okay, perfect.
yes.
That's
Get
great.
that done.
Okay.
Okay.
And then a initial setting, but I noticed it's an out of county bond and I'm afraid, I don't remember if I notified the bondsman, to be fair. So I'm going to reset that and contact them.
Anything else?
Nope, we're done.
All right,
And
thank you.
here's your punishment charge. Lacey has it done.
Okay,
And I've handed it to both sides already.
all right, let's give.
When we're going to be signing this, our application for probation. Which always is a sign. So the probation.
We now recall.
I'm sorry.
When you're ready. Laurie, you're in.
Judge,
We now recall cause number 23CR1. The state of Texas versus Faisal Atari. The defendant is present with his attorney and the state's attorneys. All right, we're about to start the punishment phase. The defendant needs to swear in front of this lady
Yes.
for his qualification for probation.
And then I also need to fingerprint the defendant as well.
Just that. Applying for, doesn't mean you're gonna get. Exactly. You don't sign that. Okay, then you don't want to, that relation. If you sign it, I can ask the jury for probation. You don't sign it, then I can ask the jury for probation. You want me to ask.
To be sir,
To be eligible, you gotta sign that. Let's say.
Mr. Atari, to be eligible for probation from the jury, that has to be signed.
I know, sir.
And it shows that you're qualified under the law. It's still the jury's charge, the decision. But if you don't sign it, then the only option they have is imprisonment,
The problem,
which,
if we sign probation, I have no address.
He doesn't have a place to live. He doesn't have any home anymore.
If we have,
Well,
if
then-
we know anyone here,
Well,
I can buy
if he's on-
out from 3 years and 6 months.
well, there's a difference between living the next few years in prison versus being on probation and a free
Right,
person.
find Place for
And-
them to find someplace.
I mean, but people are on probation who are not even citizens. and they're still on probation. And everyone prefers probation rather than in prison, but you might be different. It's a free world here, your choice. But you cannot be, the jury cannot even consider probating your case. That means if you're found guilty, but you could be released on terms of probation. And terms of probation, for the most part, are the things I have to do. Don't commit a crime, don't get in trouble, work, things like I have to do. Those are the same thing. I'm not on probation, but those are the same rules I have to follow for the most part. Otherwise, you have the other things, or you would have to report to a probation office like monthly, regularly, but God bless you. But I've never in my whole career heard of someone who states, I don't even want to sign the probation. I'd rather just, I'm going to go to prison and that's my only option and that's what I choose. But think about it, because you'd be the first person, but everybody has a free thought. But I've always thought freedom is a precious thing.
It's very good for very safe. Issues in the probation.
No, that's not what it was, that was the offer they made you, so.
Only there was somebody.
You've been found guilty, yes.
That's not those.
No, that's a different, that's a different, no, that's not what you said, no, that. So that's not a possibility, the jury's found you guilty. So this is if you want probation or not. If you want to sign it or not, it's kind of up to you. If you want probation or me to ask the court or the jury for probation, you got to sign that. But it's up to you. I will put the date down there because we know the 24th. I don't know what day would be to this point, but so you need to make your decision whether you want me to ask for probation or not.
If you don't sign it, their only option is prison. That's the only option they have. And it would be how much prison, and they would decide. But you'd be the first person who I've come across who has ever thought, I don't even want the option of probation. That I want you to think about it hard, because freedom is a good thing.
Yeah, I want to go. Okay. So did you? Okay, that's fine. If you don't sell it.
I do need a favor for the defendant.
Come on up here, sir. You have to get fingerprinted here by law.
That's
once you're convicted.
You have the right to front.
Now, before we move forward, Your Honor, I would like to put on the record that you would sign that. It's formal.
It's part of the record.
Oh, it's already, I guess everything we've been saying is already on the record, Your Honor.
Yes.
Is she up there? I didn't see Cam.
She's here.
Okay, then.
Owen's always here.
Okay, one more time.
You can see where I'm from and I'm sitting, so I just want to make sure.
That's all I need. You can sit back down with your attorney.
Mr. Atari, please stand. Please stand. And John, please stand. Raise your right hand. Do you solemnly swear or affirm any statements that you might be making here in a minute, the truth, the whole truth, and nothing but the truth, so help you God? Lower your hand. John, put something on the record here, because the defendant has expressed his wish that probation be excluded, as Mr. Atari is refusing to sign a document that all people who apply for probation and have the option for probation, if they want probation to be and request probation as an option, they have to sign a document which states that the person has never before been convicted in this or any other state or the United States of a felony offense. And it's my understanding that Mr. Atari has reviewed that with you, and he decides he does not want to sign the document, which would mean the option of probation would not be available, and only imprisonment it would be available for the jury. And I just want to make sure that Mr. Atari understands that fully. And if that's what he wishes, that's his right. and then it will be put into the record so that if it's ever reviewed for posterity, the reviewer would understand why the defendant made his decision that he is expressing. Go ahead.
Okay. Mr. Atari, you understand that part of the punishment could be 2 to 10 years or probation. You understand that?
That's between the sample.
Okay, all right. But before you're eligible.
He can't.
Oh, speak up so she can hear you.
You gotta speak louder so she can hear.
Okay.
Yeah, I understand.
Okay. And to be eligible for probation, you have to have no felony convictions. Is that correct? You understand that?
No felony conviction.
Right. Well, let me ask you this. Do you have any felony convictions?
No.
Okay. All right. You also understand, we've explained to you that before I can ask the jury to give you probation, before they can consider it, we have to file this application for probation. You understand?
Again. Tell me again.
Okay. This is an application for probation.
Yeah.
It's a legal document that we must file with the court before we can ask the jury to give you probation. You understand that? I'm telling you that.
Yeah.
Okay, you understand what I'm telling you,
Yeah.
correct?
Yeah.
All right. This is something that you have to sign and get notarized before the punishment phase of the trial. Okay? Do you understand what I mean by that?
No.
Okay. After you're found guilty, before the punishment starts, you have to sign and have this notarized.
Again, after I found guilty.
Right. And you were found guilty yesterday, correct?
That's what they say. Yeah.
Well, that's what that means. Okay. And we're about to start the punishment.
Yeah.
Okay. So if you want probation, you have to sign this document, but you're telling the court you do not want to sign this document. Is that correct?
They can give, if they give me probation. That's my question. If they give me probation, what my experience in the jail, all the people, they have address. I have no address. I cannot find address when I stay in the jail.
Okay. So you don't want to do probation. You don't want me to ask for probation. If you don't want me to ask for probation, just say it and we can move on. Do you want me to request probation from the jury? Yes or no? Okay, let me ask you, oh wait, you would rather be probation?
No.
No? Okay. Okay, so for the record, you do not want me to request probation, is that correct?
No.
What's that?
No.
That's correct.
Yeah, it's correct.
Okay, all right, thank you.
Okay, never mind. And Mr. Atari, you're making that decision voluntarily, and correct? You're voluntarily saying that you do not wish probation to be argued on your behalf.
I'm not understand the law. I am not from
I know
here.
this is-
That's why I cannot. I don't know.
Okay, do you understand what probation is?
I know, but I understand something from the people from
Okay.
jail from.
But if you do not sign the document, then he can't argue probation for you, and the jury will not be able to consider that, which means the only thing they can consider is sentencing you to imprisonment for no less than 2 nor more than 10 years confinement in prison. That gives them an option to consider granting you probation and keeping you free from going to prison so long as you follow the terms and conditions of probation.
Mr. David, I have a question.
Go ahead.
Already they convict me about guilty. I am not guilty, but they convict me guilty.
That's their choice.
Now the charge from 2 to 3 to 2 to 10 years.
Yes, sir.
Okay. Already I am in the jail 3 years and 6 months. That's meaning like same what is they.
I see what you're saying.
Like times.
You get, and yeah, you're going to get credit for all time you've served. You will be given credit for all time you've served. And if they sentence you to imprisonment, they would, if it's if it's less or equal to the length of time you've been in prison, you'll be released. You won't stay in long. You will be just in there for them to process it. But if they sentence you to a longer period, up to 10 years, you might be in prison longer than the time you have served up to now. But I see what you're saying is you're thinking you could have served, if they sentence you to imprisonment, it may be a period of time where you won't be in prison anymore or confined. You could be released. You have had enough time. That's a thought. You've had some time to think about it. Are you stating that you would prefer not to be considered for probation? That's the choice. Yes?
Yes.
Or you're making that you're making that decision voluntarily and after discussions with your attorney?
What meaning voluntary?
Free will. Nobody's forcing you.
Of course, nobody. I'm not talking with.
Yeah, this is your choice.
Yeah. my
Okay.
choice.
All right. Then we'll move forward and you'll be subject to that full range of imprisonment, but you will be given credit for all time you have served in custody. You're going to be given credit for that already. All right, bring the jury in. Thank you. All right, y'all have looked at this.
Things out.
The instruction on probation is excluded.
And you.
And the last three options of probation are taken out, so it's just years and fine.
And I guess the instructions on probation, Your Honor. We need to take that one out.
Yes, instructions.
The third page. Yeah, you can actually do that, yeah. It's been that cheap, right? But we don't, it's a physical. I'll just put the application in for that. Yeah. Yeah. Even more. Yeah. Quite a bit of time.
Camera where you want it, Your Honor.
Real quick,
Sir,
All right, this looks cool.
let me know if I need to come back.
Thank you. Stand by, ladies and gentlemen. Oh,
Yes, sir.
clockwise, about 15 degrees. Thank you. That's good. And
No.
just clockwise, 5 degrees. God bless you. The other clockwise.
Okay, thank you, Judge.
Can I do the same thing?
That's good. You get.
Yes.
Just clockwise on the other
Um, all right, ladies and gentlemen, as you know, yesterday, and for the record, all parties are present, including the defendant, his attorney, and the state's attorneys, and the jury is present. Yesterday, the defendant was found guilty by a jury verdict of this third-degree felony of assault, family or house member violence by choked or by squeezing the victim's neck with his hands, choking. And this brings us to a close of phase one. We are now moving forward in phase two, the punishment phase of this trial. Please note that you are under the same instructions the court has already given to you. Do the parties wish to make any opening statements?
No, Your Honor.
Or the defense?
No, Your Honor.
All right, this is an opportunity for the parties to present any additional evidence. And again, you are required to consider all of the evidence already presented for your deliberations in this punishment phase, as well as what you did in the guilt or innocence phase. What says the state?
Judge, after speaking to my witnesses, there's nothing substantial more that I can add, so we're gonna rest.
And
Yeah.
no, your defense. Anything further?
Nothing further. Your Honor.
Okay, so the defense rests. If Mr. Atari's talking to you, just y'all need to.
We rest, Your Honor.
All right. Ladies and gentlemen, the evidence is now before you from the evidence previously presented in the guilt or innocence phase. I'm about to read to you the jury charge, which is much shorter than the guilt or innocence stage, for this punishment phase, which contains all the law applicable in this case for punishment. In continuing to discharge your responsibilities as jurors, you must continue to observe all the instructions previously given to you. And again, please listen carefully, as I know you will, as I read this charge to you. It, as before, in the guilt or innocence phase, will be left with you to refer to as necessary during your deliberations. Members of the jury, you have found the defendant guilty of the offense of assault, family, or household member by impeding normal breathing or circulation, choking. It becomes your responsibility to assess the proper punishment. This offense under our law is a third-degree felony. Third-degree felony punishment. An individual adjudged guilty of a felony of the third degree shall be punished by confinement in the institutional division of the Texas Department of Criminal Justice, prison, in other words, for any term of not more than 10 years or less than 2 years. In addition to imprisonment, an individual adjudged guilty of a felony of the third degree may be punished by a fine not to exceed $10,000. Good time credit and parole. Under the law applicable in this case, the defendant, if sentenced to a term of imprisonment, may earn time off the period of incarceration imposed through the award of good conduct time. Prison authorities may award good conduct time to a prisoner who exhibits good behavior, diligence in carrying out prison work assignments, and attempts at rehabilitation. If a prisoner engages in misconduct, prison authorities may also take away all or part of any good conduct time earned by the prisoner. It is also possible that the length of time for which the defendant will be in prison might be reduced by the award of parole. Under the law applicable in this case, if the defendant is sentenced to a term of imprisonment, he will not become eligible for parole until the actual time served plus any good conduct time earned equals 1/4 or 1/4 of the sentence imposed. Eligibility for parole does not guarantee that parole will be granted. It cannot accurately be predicted how the parole law and good conduct time might be applied to this defendant if he is sentenced to a term of imprisonment, because the application of these laws will depend on decisions made by prison and parole authorities. Now, the law states that you may consider the existence of the parole law and good conduct time. However, you are not to consider the extent to which good conduct time may be awarded to or forfeited by this particular defendant, because again, those decisions are not in our hands. And you are not to consider the manner in which the parole law may be applied to this particular defendant, because again, that would be in the hands of parole authorities. Stand by. Stand by. Something that is missing and in our haste to try to catch up to this morning's docket that took longer than we expected. That was not placed into the jury charge. It's a very short instruction.
I missed it.
Yes. And then here's
Here,
the parties.
for each one, for your files. All right, general instructions, ladies and gentlemen. The attached verdict forms are supplied for your use. When you have reached your verdict, your foreperson should fill in the appropriate form and sign their name as foreperson. In arriving at your verdict, it's not proper to fix the punishment you assess by any system of averaging. Your verdict must be determined only by a full, fair, and free exercise of the opinions of each juror based upon the evidence presented, and your verdict, as before, must be unanimous. Your failure to follow the law contained in this charge could result in a mistrial being declared, and your deliberate violation of these instructions could result in your being held in contempt of court. I have to say that by the law, and I trust you, all of you. All right, two options here, ladies and gentlemen. One option, we, the jury, assess the defendant's punishment at confinement in the institutional division of the Texas Department of Criminal Justice prison for a term of blank years, no less than 2, no more than 10, a place for the foreperson to sign. And your other option is, we, the jury, assess the defendant's punishment at confinement in prison for a term of years, no less than 2, nor more than 10. We further assess a fine of blank dollars not to exceed $10,000. Only one verdict form can be signed. As before, the state of Texas may open and close final arguments. What says the state?
State of Texas will waive its right to open and reserve its right to close, Your Honor.
Mr. West, on behalf of the defense, you may go forward.
Thank you, Your Honor. I look at the clock to make sure I say good morning. It's still morning. Good morning, everyone. Sorry we're taking a little longer to get started here. There's a lot of other things not related to this case, but other work that was getting done in here. We were all, even though it wasn't this case, we were all still involved in a lot of that stuff. So apologize for that. although we don't agree with your decision, we respect your decision. This is what the judicial system is about, okay? So now we're at the, some people think the harder part of the decisions is what to do now, okay? In some cases, jurors are like, oh, absolutely, he's guilty, she's guilty, not guilty. That's pretty easy. But then decide, what do you do? It's the punishment. Right? You have I would say a big range. I mean, it's one of the smaller ranges we have. It's not, you don't get 5 to life, it's, 2 to 10, but it's still someone's life that's in your hands. What to do, how much time to give. Is this worth 10 years? Is it worth 2 years? Is it worth the extremes? I don't know. Right. I'm not gonna tell you, give this number. That's not my decision to make. That's your decision. You need to make your decision, what you think is right in this case. But I will point out a couple factors that may help. You heard no evidence my client's ever been in trouble before. It's his first time. Nobody brought anything up about that. He'd only been in the US for about 8 months. Okay. You heard about the conflict between him and his wife. Okay. That she wants it to be over with, wants a divorce, doesn't want to file a divorce. She's left. So like I argued in my closing argument, actually, I'm not going to argue the same thing. Y'all heard it. We're not bringing a lot of other evidence up, either me or the state, Mr. Letter and I, because you've heard pretty much everything you could possibly hear. There's not much more that we can give you. So rely back on what you heard yesterday. Okay, this is not a situation where at the end of the trial, we give you a bunch of more stuff that you didn't know about. Like, oh, it changes your mind. It's not everything. There's nothing that you haven't heard. I would just request something on the low end. Like I said, I'm not going to tell you, give them 2, give them 3, give them 4. I'm not going to do that. But I would request something a low end. The victim in this case is gone. She's hidden, safe. She doesn't want him to know where she's at. She didn't come here for trial. She doesn't want to file for divorce because she doesn't want him to have her address. She's moved on. He's here. So there's not a situation where you have to keep him away from her. How much do you need to keep him away from society? I don't know. It's your decision on to make. Punishment is punishment. 2 years, 3 years, 4 years, 5 years, up to 10 years. It's up to you, but I would request somewhere along the lower half of that would be appropriate for a case like this.
State of Texas. Morning. You notice I have my serious face on today. I sit back sometimes and reflect on trials and try to decide, is there something that could have been done different, something that we could have done to maybe somewhere in the past save a family, try to make things right. And he's had every opportunity to do that. Even when he was on the stand earlier yesterday, when he was talking, he had every opportunity just to look you in the eye and say, I'm sorry. But it's all about control, and it still is. You notice there's no option for probation. We talked about that earlier on. That option has been removed. It's no longer here. So you're just facing deciding what to do with him on prison time. And I want you to think about how many years, this is just a bug in your ear, that how many years that Julie Lozano had to wake up with a pit in her stomach, had to worry about getting off work late, had to go through the humiliation of having her panties removed and checked, her genitals checked, having herself urinated on, her pillow urinated on, all the humiliation of things that she's had to endure over all these years, and all the times that she was alone and didn't have help. She was isolated, and he knew that. That's why he could take advantage of the situation he took advantage of. And even when she decided to tell someone, it wasn't an authority, it was just a friend, because she just didn't know what to do. And after all these years, She doesn't want him to know where she and the kids are because she's afraid. I want you to think about that. If you're, and there's a lot of females, but even the guys, there's just, you think about someone who is so vulnerable that they just can't get help and they want help. And then on the other end, you've got the one that's dominating them and abusing them and humiliating them and degrading them. And then he comes up here and says, feel sorry for me, give me something less. And honestly, looking at the punishment range, I would tell you, I don't think it's enough. I don't think it's enough to go through that kind of degradation, to go through that kind of humiliation, to go through that kind of pain. And then at the end of it, he blames her for the fact that he gets crazy sometimes. See, here's the thing. When he was talking to the detective, that's why I brought that up. He gets a little crazy sometimes. You've seen him when he's got a little angry. I want you to picture that anger when he gets a little crazy. Because if that's just arguing with me, imagine what it's like when he's dominating his smaller, helpless, weak, insecure wife and putting his hands around her neck. And there's only one reason you do that. We talked about that in Word I. And the only reason he stopped, according to her, is because he noticed he was bleeding. He stopped to take care of himself and then still humiliated her by cleaning the blood up by using the bleach. So yeah, 2 to 10 is not enough, but that's what the law says. So here's what I'm going to ask you to do, and I'm going to look you now while I do it because I have no qualms about asking you. I'm going to ask you to give him not only the 10 years, but I'm going to ask you to show him that this isn't enough by putting that extra $10,000 fine on the end of it as an exclamation point to say, I wish we could give you more because you deserve more for what you did to her. You deserve a lot more because she's got a lifetime now of being afraid of when you get out, you're going to find her. Because in this world, you can't hide from anybody. And now she's got a lifetime of waiting, watching, worrying about her kids, worrying about the fact that one day that door is going to open and there he is. So I'm asking you to let him know that not only is it not enough, but you wish you could give him more. 10 years, $10,000 fine. I look forward to your verdict. Ladies and gentlemen of the jury, at this time I'm tendering the jury charge to the bailiff. Please step down from the jury box, follow the bailiff into the deliberation room. We will await your verdict. Alternates, again, I'm going to ask you to step aside, stay close by, and hold vigil. Thank you very much for your patience on that. Right.
They make you more.
Okay, so that's.
Yeah.
Anyway. It's fine.
Make sure you spell my name right.
Part of the punishment was prison.
So we go with.
We are in recess awaiting a verdict. Thank you.
This courtroom hearing wasn't about whether a man had a criminal record. Everyone already knew he did. The real question was whether his past made him too dangerous to receive the legal relief he was requesting. The judge carefully reviewed the defendant's history, which stretched back more than 2 decades. The record included a weapons conviction, evading police, a DWI, child endangerment, and a federal firearm conviction. While some of the offenses were old, the court explained that criminal history still matters when determining dangerousness under the law. The discussion quickly focused on one conviction in particular, child endangerment. The defendant was asked to explain what happened. He admitted that years earlier he had been drinking and driving when police stopped him. During questioning, the court learned that an 8-month-old baby was riding in the vehicle at the time. According to the records reviewed during the hearing, witnesses reported the vehicle was swerving, striking curbs, and failing to stay in its lane. Officers noted signs of intoxication, including slurred speech and failed sobriety tests. The judge carefully reviewed those facts while considering whether that past conduct demonstrated dangerous behavior. The defense argued that the incident happened many years ago and that the defendant had changed his life since then. He was now employed at a funeral home, had maintained steady work, and had stayed out of serious trouble for years. His attorney emphasized that the court should look at who he is today, rather than focusing entirely on mistakes from decades ago. But the judge wasn't convinced the issue was that simple. The court explained that under recent legal decisions, the analysis focused heavily on criminal history. Some courtroom moments aren't about the original charge at all. They're about whether someone respects the court process. And in this case, the judge had clearly run out of patience. The hearing centered on a defendant who had accumulated multiple traffic-related cases and, according to the court record, repeatedly failed to appear. As the judge reviewed the history, the frustration became obvious. The defendant had missed court dates going back years, with several opportunities already given to resolve the matter. Instead of seeing progress, the court saw a pattern of no-shows, missed deadlines, and unpaid obligations. When the defendant finally appeared, the judge didn't hold back. He questioned how someone could ignore court orders for so long and then expect everything to be handled casually. The defendant explained that she had moved and lived in another state, but the judge wasn't persuaded. In his view, living a few hours away wasn't a valid excuse for repeatedly ignoring court appearances. He pointed out that modern technology even allowed court participation by Zoom in some circumstances, making the repeated absences even harder to justify. As the judge reviewed the case history, he listed one missed appearance after another. The records show years of delays, failures to appear, and unresolved matters. At one point, he openly questioned what the court was supposed to do when a defendant continuously ignored orders. His concern wasn't just about the traffic offenses, it was about accountability. Courts rely on people showing up when ordered, and when someone repeatedly fails to do so, judges often view that as a direct challenge to the judicial process itself. Because of that history, the judge determined that a simple promise to appear wasn't enough. He explained that the